I have the honor of introducing our first speaker, Justice Clint Bolick. He was appointed to the Arizona Supreme Court in 2016. Prior to joining the court, Justice Bolick litigated constitutional cases in state and federal court from coast to coast, including the United States Supreme Court. Among other positions, he served as the Vice President for litigation at the Goldwater Institute, and as co-founder and Vice President for litigation, at the Institute of Justice. I did get that right. He has litigated in support of school choice and a variety of other issues. Justice Bolick received his JD from the University of California, Davis, and I understand one of his classmates is a CAPE board member. You'll find that out later. And his Bachelor's of Art from Drew University in my home state of New Jersey. He's written a dozen books and hundreds of articles, and we welcome your wisdom and words now. Thank you for being here, Justice Bolick.
Well, what a pleasure to be here today. What an august occasion. We actually, in my book, are celebrating not one important anniversary, but two. And I see Mark over there. So this is the 100th anniversary of Pierce versus Society of Sisters, an incredibly important case that continues to resonate in American jurisprudence. In fact, the U.S. Supreme Court, and you will hear this from Nicole after me, decided it was such an important case that it celebrated the 100th anniversary of Pierce with the Mahmoud decision, which is equally resonant in American jurisprudence. And what an incredible bookend to a history of recognizing parental rights. But in addition to that, this is the 42nd anniversary of my affiliation with CAPE. 42 years ago, barely 6 months out of law school, having passed the California bar exam, and I still think they made a mathematical error, but it was to my benefit, so I'm happy about it. I learned that the United States Supreme Court had granted review in a case that I hoped would be a turning point in jurisprudence toward school choice. And I cast about for people who would let this young punk lawyer represent them in a friend of the court brief in the United States Supreme Court. And I discovered fellow UC Davis alumnus Mark Siegel, who was affiliated with a young organization called CAPE. It was not even a teenager yet. And in the year 1983, we worked together. And the case in which that brief was submitted was a case called Mueller versus Allen. And those of you who are familiar with the jurisprudence in this area know how important that case was, upholding Minnesota's system of tuition tax deductions that could be used, among other things, for religious schools. Now, I have to say I must not have done a very good job because CAPE never hired me as a lawyer again, notwithstanding my really good rates, which were free. But no, that was a wonderful association. And as I was planning for my talk here today, I thought to myself, wow, what a great start that was. And so much has happened since then. I am also delighted to have a 1-2 combination with my dear friend Nicole Garnett. Nicole and I worked together at the Institute for Justice. I am proud to say that she was my second chair in a number of school choice cases, which is, I think that would, if we work together again, surely flip. I would be honored to be her second chair. But we worked together particularly in the Milwaukee school choice program. I remember being holed up together for days in the Bradley Foundation apartment in Milwaukee as we were planning for the litigation in Milwaukee, which, as you all know, turned out well But it was just great to have that working relationship. after that situation, she said, what on earth am I going to do for an encore here? You know, having worked on school choice, having worked with Clint, she's like, all right, I'm going to clerk for Clarence Thomas. And that is exactly what she ended up doing, and now serves on the faculty at Notre Dame Law School and has just been, in my view, the leading scholar on both free exercise and Establishment Clause issues. And I am so glad that she has had that career, which will continue to flourish, because even though so much has happened, there is so much yet more that will almost certainly be happening. Just to let you know how we decided to divide our remarks, I am going to take you from Pierce through Zellman, the case that upheld the Cleveland school choice program. And then Nicole is going to take it from there. And again, you know, that seemed to be the culmination, that seemed to be the grand prize. But as we learned, and I'm paraphrasing Winston Churchill here when he was speaking after a battle in North Africa, the British won against the Germans in World War II, he said, this is not the end. It's not even the beginning of the end. It may be the end of the beginning. And that is really where Zellman was. I certainly didn't appreciate that at the time, but as incredibly important a milestone as it was, this is just an amazing time for foment on free exercise and Establishment Clause issues. And I am excited that she is going to bring us up to date, because I teach constitutional law, and she is going to be my human cheat sheet as I teach the more recent cases in this area. Taking you back to even really before the time of Pierce versus Society of Sisters a century ago, it is hard to overstate the degree of nativism that existed in our country following the Civil War, all the way up through at least the mid-1920s. And one of the goals of the nativists was to eradicate alternative schools, because the immigrants, so many of the immigrants, particularly from Europe, were bringing their schools with them. And so one of their political goals was to eradicate alternative schools through a variety of means. Now, when I talk about nativism during this time, it really was not concentrated in the South. The South was primarily focused on subjugating blacks, but the nativists focused in the middle states and in the western states, and found a lot of fertile territory in these areas. A couple of examples of other instances of just breathtaking nativism that were going on at the time. And one of the things about these nativists was that they were equal opportunity nativists. They hated everybody, not just Eastern European immigrants, but Asian immigrants, Native Americans, you name it. And one of the examples during this period was a case that went to the United States Supreme Court in the late 1800s. Actually, one of my very, very favorite cases. Almost all the cases I'm going to talk about today are among my favorite cases. But in San Francisco, the city of San Francisco was very distressed about the number of Chinese immigrants that were coming into their city and doing this horrible, horrible thing of opening laundries. And so the San Francisco Board of Supervisors passed a law that was seemingly innocuous, but it said all laundries have to be made of brick. There can be no wooden laundries. But there will be an exemption here. The Board of Supervisors can make case-by-case exceptions to this rule. Well, it turns out that almost all of the brick laundry establishments during this time were owned by white people, and almost all of the wooden ones were owned by Chinese people. And so this law literally drove Chinese laundromats out of business. Plaintiff Yik Wo went to the United States Supreme Court, and the United States Supreme Court, applying the Equal Protection Clause, rather newly minted under the 14th Amendment, held that this was an unconstitutional deprivation of economic liberty, that even though the law was neutral on its face, it was applied with racial animus, and therefore the law was struck down. An even more pernicious example of nativism happened in my adopted state of Arizona. I came across a book, and it almost doesn't seem like it can possibly be real. But the name of the book is The Great Arizona Orphan Abduction, and it really should be made into a movie, if for no other reason than the book is so badly written. It would really be so much better on the screen. But again, in the late 1800s, before Arizona was a state, an Irish orphanage in New York had an excess of Irish orphans, and they sent a train car full of Irish orphans to Phoenix by train to place them with Catholic families. The train arrives, the local priest says, okay, who are my Catholic families? It turns out they're all Mexican American. The white families were all Protestant. He placed them with Catholic families, and the white members of the community absolutely found this totally, these blue-eyed, blonde-haired kids living with Mexican families was simply intolerable. And they organized a posse, and in the middle of the night went from home to home, kidnapped the children, and place them in homes with members of their same race. This case, too, went all the way up to the United States Supreme Court, which upheld the abductions, the result of the abductions, and said, these are families now. We're gonna let this stand. But it's just the instances of nativism during this period were just absolutely amazing. And they not only didn't dissipate at the turn of the century, they increased, in large part because immigration increased. And most of the immigrants were Catholic, and many of them brought Catholic schools with them. Some of them even committed a more unpardonable sin, which is to bring their native language with them. And so we saw a two-pronged issue with regard to education. And fueling this effort was an organization called the Ku Klux Klan. The KKK at the time was a very popular organization because of a movie that had come out called The Birth of a Nation, which heroized the Klan and its efforts to maintain the purity of the white race. And the Klan found strong political influence in a number of states, including, it would be rather surprising today, perhaps, the state of Oregon, where in the early 1920s it became a major political force in that state. By the way, Mark Siegel is going to speak more about the Oregon situation. I'm only going to touch lightly on the history here, but the Klan proposed a ballot measure requiring compulsory education in public schools only for kids ages 8 to 16. So it wasn't just the KKK that was fueling this movement. Oddly enough, the KKK was in common cause with progressive forces at the time. This was the height of the idea of the common school, the notion that every student should attend public schools for civics purposes. And so progressives and the Klan and other nativists supported this ballot measure. Well, the private schools in the state recognized if this passes, we're done. Because if we can only provide after school and that sort of thing, we simply are not going to be able to survive economically. And a number of groups put together a coalition in opposition, led by the Catholics, but supported by other religious groups as well. And this is, by the way, when I did my own school choice litigation in the 90s and early in this century, one of the things I found was how ecumenical the school choice group was. Now, the Catholics would fight with one another, but they got along really well with the other religious groups in their coalition. And I suspect that anyone who laughed at that is probably Catholic and knows exactly what I'm talking about. Every time I came to DC during that time was to do battle with the National Catholic Conference, which was not our best ally in those cases. But it was a very ecumenical approach. But the proponents of the ballot measure made a brilliant strategic move. They did not call this measure a compulsory public school attendance law. They simply made it the compulsory education law. Guess what? There already was a compulsory education law. It enjoyed massive support among Oregonians, including among many private school proponents and attendees. And so the opponents not only, and you see this, of course, in political battles today, the opponents couldn't simply make arguments about the importance of parental autonomy or the importance of having choices in education. They also had to overcome the misleading arguments that were made in favor of the ballot measure. A particularly demagogic candidate for governor embraced the idea. He was very, very eloquent. And ultimately, not only that candidate, but the ballot measure passed as well. And so the private schools in Oregon faced extinction. So in this country, what do you do if you have an issue like that you have lost in the public arena? Well, thankfully, and hopefully for all time, you go to court and you challenge it. And this turned out to be one of the first public interest lawsuits in the country. And it was extremely effective. And by the way, for those of you who are not familiar with this book and who are interested in the history of this case, I strongly recommend a book that I read on this case called Cross Purposes by Paula Abrams. I love that title because I love double entendres, and it very much is one. And she chronicles the history of the case and the litigation all the way through. And the lead plaintiff was St. Mary's School, a Catholic school that was started in 1859 in Oregon. And I just absolutely love this. It was a girls' school, and it started with 3 Catholic students, 2 Jewish students, and 1 Episcopalian student. And one of the things, when I took on the mantle of school choice defense in the early 1990s, apart from I did my teacher training in undergraduate in a Catholic girls' college, which being the only male there was a pretty cool thing. But other than that, I had never set foot in a Catholic school in my entire life. In fact, I had only set foot in public schools. And I was astounded. You know, I remember in New Jersey, at the time, we called them parochial schools. And when I think of the term parochial, narrow-minded, you know, homogenous, and all of this, and touring as I did Catholic schools in Milwaukee, where the first school choice case was, like, oh my gosh, how did Catholic schools allow themselves to be labeled as parochial? These are the least parochial schools I have ever encountered. They are racially diverse. They are religiously diverse in many instances. They are economically diverse. They are philosophically diverse. They are liberal in the great intellectual tradition. And perhaps seeing that through my own eyes of not having had prior accurate preconceptions may have made me a more effective advocate, because I became a huge convert to Catholic education during that time. But in any event, St. Mary's was an early form of that. And St. Mary's took up the cause of being one of the two lead plaintiffs. The other lead plaintiff, and by the way, these were schools that were recruited by the lawyers. That is a classic public interest litigation tool, to choose the best plaintiffs, the plaintiffs that will resonate in the biggest possible way, was a military academy, a boys' school, Hill Military Academy, purely secular, but they too were going to be wiped out. They had nothing to do with the immigration issue at all, and yet they were going to be swept aside if this law was upheld. Now, the lawsuit goes forward, and what many of you who may not be that familiar with the case might ask right away, or just think right away, is obviously this is going to be a religious liberty lawsuit. St. Mary's Academy, it's directed toward Catholics, animated by religious discrimination. And so why don't they lead off with the religious liberty issue? Well, a very good reason. The U.S. Supreme Court had not yet applied the Bill of Rights against the states. There was no federal constitutional guarantee of free speech, of free religion, of gun rights, or any of the other Bill of Rights protections that are so well known to us. So all they had were the terms of the 14th Amendment: equal protection, due process, and a provision that almost no one knows about that is near and dear to my heart, the privileges or immunities of citizenship. That clause had been removed in 1873 in a disastrous case called the Slaughterhouse Cases. If you're interested in that, I've written a book on it. But for present purposes, the only two possibilities are equal protection and due process. So what do the plaintiffs do? And of course, religion is very much in the background here, and they could have chosen to try to incorporate the free exercise of religion into their litigation. Have no idea what would have happened if they had done that, but it turns out that they didn't need to, because in a number of cases early in the century, the court had recognized that the due process clause protected not just process, but certain rights that were embodied in the concepts of liberty, life, liberty, and property, which are protected under the due process clause. And most notably, and perhaps most unexpectedly, economic rights, freedom of contract, were recognized as rights that were protected by due process. Now, this concept became known over time. At the time, no one called it this, but over time, this became known as substantive due process. The idea that due process does not just protect property rights or process rights, but substantive rights as well, especially common law rights. And in a case that has since been overturned, Lochner versus New York, the state of New York regulated the hours of people working in bakeries. Interestingly, the backdrop of this case, anti-immigrant also. Lochner, a German baker. Who are his workers? His family in New York. Who are the people pushing for this minimum or maximum hours law? Big bakeries trying to put the immigrant bakers out of business. The Supreme Court, over an objection from Justice Holmes, says this is within the liberty protected by the Due Process Clause. Then this idea sits around, the court has clearly embraced it, and it continues to thrive in the 1920s. So as the Pierce case is beginning to work its way through the courts, the United States Supreme Court decides another case. And in fact, Pierce, although by far the most famous of the cases, was part of a trilogy of cases that recognized parental autonomy and protected the right of people to send their kids to the school of their choice in the 1920s. But the first case was a case called Meyer versus Nebraska, which was decided in 1923. This involved a restriction against the teaching of foreign languages before a certain age. And a teacher was arrested for teaching German during recess. And the idea of teaching German, oh my gosh, this is so awful. And in fact, the proponents of the law said that the purpose of the law was to educate children so that, the purpose of teaching foreign languages was the reason it was so bad, is that the purpose is to educate them so that they must always think in that language, and as a consequence, naturally inculcate in them the ideas and sentiments foreign to the best interests of this country. So this is raw nativism. If you learn in German, you become a German in your thinking. Now, this poor guy is teaching German during recess, right? It's not, the only language. But regardless, the idea that learning a foreign language is dangerous to America is one that animates this law, and that goes before the United States Supreme Court. And the United States Supreme Court, drawing upon the concept that had been adopted in Lochner, says that the Due Process Clause, without doubt, denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home, and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. So this case, Meyer in 1923, is decided on the basis of the school teacher's freedom to contract. It's not yet a full-fledged parental liberty right, and it is not even a personal right. It is an economic right, but nonetheless, the court marks an important step. And so, of course, the plaintiffs in the Meyer case take a great deal of wisdom from this case in terms of the strategy, and note that the plaintiffs are not, in that case, are not parents. They are schools. They are schools that are about to lose their property and their corporate existence. So they're building on the idea of Meyer. They're arguing parental autonomy, but the strongest argument that they feel they have is what came out of the Meyer case. So around this time, I learned a lot about how things have changed as I was researching this case in terms of Supreme Court strategy, and I loved this story in the book, Cross Purposes. So it turns out that when lawyers used to have Supreme Court strategy sessions, they could do it in the Supreme Court. They would make a conference room available and put their heads together and plot out Supreme Court strategy. And the lawyers for the plaintiffs in Pierce versus Society of Sisters did exactly that. And as they're meeting, Chief Justice Taft happens to come in, and they're like, "Oh, while you're here, Chief, can we ask you for extra time in our argument because the issues are so lengthy and all of that?" And he said, "I don't see why you want any more time. In principle, this case is simply the Meyer case over again." Boy, I would love for a judge to have told me, "Hey, you got it, Clint, don't worry about it." But that must have just been a very happy moment for the lawyers. They argue the case, and interestingly, the state at this point wraps itself not so much in nativism per se, but it wraps itself in the Red Scare that is occurring in the 1920s. So, you had Sacco and Vanzetti, you had these foreign anarchists, and this is one of the arguments. This is from their brief. Oh my God, this just blows me away. It says, if the Oregon school law is to be held unconstitutional, it is not only a possibility, but almost a certainty that within a few years, the great centers of population in our country will be dotted with elementary schools, which instead of being read on the outside, will be read on the inside. Not sure I've heard too many Catholic schools being accused of being read on the inside, right? But I mean, just such inflammatory rhetoric. The court rejects it unanimously. Meyer was 7-2. This one is 9-0. Even Holmes in the second from the left in the bottom row there, no friend of freedom in most instances. Nonetheless joins the court. And, I think surely all of you are familiar with the verbiage in Pierce versus Society of Sisters, but it is worth repeating and certainly worth celebrating. The court goes far beyond where it went in Meyer versus Nebraska, and the court says, the Act of 1922 unreasonably interferes with the liberty of parents and guardians to direct the upbringing and education of their children under their control. The fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty to recognize and prepare him for additional obligations. The cornerstone concept of parental autonomy and control over the education of children is firmly established in Pierce. The third case in the trilogy is Farrington versus Tokashigi. It involves limiting the hours of education in Japanese that children in Hawaii can hold. The court again strikes down the law, and it says it goes far beyond the mere regulation of privately supported schools where children obtain instruction deemed valuable by their parents and which is not obviously in great conflict with any public interest. Unlike the Lochner decision, which is overturned and vilified in subsequent years, Meyer, Pierce, and Farrington are good law. And they are very good law, as we'll see with Nicole's talk, talking about the recent Mahmoud decision as well. So after these decisions, a great deal happens that actually makes the world more difficult for those of us who later would come together to fight for school choice. One of the nativist pushes that was perhaps the most successful nativist push actually preceded the Ku Klux Klan law, and it was advocated by the person who at that time was the king of nativists, a United States senator named James G. Blaine. Blaine failed in getting a federal constitutional prohibition against funding sectarian schools, but he convinced or otherwise coerced 36 states into adopting these so-called Blaine Amendments. They sound in today's time so benign. No funding for sectarian schools. One of the reasons I am a textualist, meaning that I apply constitutional provisions and statutes according to their original, plain, common understanding, is that the meaning of terms changes over time. Sectarian today means religious. At the time, it meant Catholic. Public schools were Protestant schools, and this mechanism was designed to perpetuate the monopoly that Protestants had over public education. So you could see how these amendments worked in tandem with the KKK's effort to get kids to attend public schools only. And by the way, the rhetoric that was used by the KKK was one flag, one school. And the idea was to promote pure Americanism. When's the last time public schools were accused of teaching pure Americanism? But nonetheless, this was the rhetoric, very clever rhetoric that was used. So you've got the Blaine Amendments existing at the state level. You've got you have this foundation of of parental liberty, but then what comes along is a U.S. Supreme Court that begins to apply the Free Exercise Clause and the Establishment Clause against the states, but it expands the Establishment Clause beyond recognition. The First Amendment prohibits Congress from making a law respecting the establishment of religion. We all know what happened with those words. They became separation of church and state. I often ask my students, where can I find separation of church and state in the Constitution? The answer is almost reflexively, the First Amendment. I say, I just looked there and I don't see it. I see, I see a restriction on the establishment of religion. Nonetheless, the court made things very, very difficult, so that when the idea of allowing public funds to flow to private schools and to religiously affiliated schools became popular in the 60s and 70s, the precedents were strongly against them, particularly a case called Committee for Public Education versus Nyquist, which struck down what was called parochiade in New York and Pennsylvania in 1973, holding that any funding of religious schools was unconstitutional. This was the starting point that we had to confront with Mueller versus Allen in 1983. Fast forward, the court begins to say, indirect aid that is passed to private schools only as the result of choices made by parents might be okay. Our opponents called it money laundering, which really upset me. And in fact, in one brief in Cleveland, they said that parents were, I will never forget this, inconsequential conduits for the passage of money from the state to the schools. We had buttons made, inconsequential conduit, and we gave them to the parents to wear proudly. I could go off on that, but I won't. Yes, they're the early deplorables. But in any event, it was a very, very tough road to hoe. One of my litigation strategies always was, and I know Nicole will remember this, when you are defending a law or on the other side of someone challenging something, they will always put their strongest arguments first. They will frame the debate in a way that is advantageous to them. And the way they framed this debate was the Establishment Clause, separation of church and state. Very, very early on, we said we will not allow them to frame the debate in those terms. And so all of our briefs began with two cases that had nothing to do with the establishment of religion. Pierce versus Society of Sisters. The idea that in America, parents, not the government, has primary control over the education of children, and Brown versus Board of Education, the guarantee of an equal educational opportunity for every school child. Wasn't happening in Milwaukee, wasn't happening in Cleveland, wasn't happening in the myriad cities and rural areas around the country where public education was doing a terrible job, especially for kids who needed it the most. And the way I put it to my colleagues, we didn't get to conference strategy in the US Supreme Court, but at the Institute for Justice, I would say, if this case is about the establishment of religion, we lose. If it is about education, we win. Turns out, and there's another book you can read, I don't get royalties for this, it's called Voucher Wars, that recounts the 12 years of litigation from 2000 till 2003, culminating in the Zellman decision in the US Supreme Court. Nicole Garnett is prominently featured in that book. But it was a long, difficult road. We finally get to the United States Supreme Court, and we know it is going to be a 5-4 decision. We just don't know which way. The person who is going to decide the case is a fellow Arizonan, Sandra Day O'Connor. Trust me, every word in every brief was directed to Sandra Day O'Connor. And we knew how much she cared about education, but also she was very divided on the issue of school choice, on the issue of Establishment Clause. So we get to the U.S. Supreme Court, and I just happened to walk past there this morning. I didn't just happen to. It was kind of, in prep for this today. And I pictured the day of our argument in the U.S. Supreme Court. I don't know whether things have changed, but at that time, you couldn't reserve space to have a rally. It was first come, first served. Can you imagine how difficult that would be? We had 16 buses of parents from all over the country who arrived that day, and an equal number of public school teachers and advocates. Well, the teachers were tardy, and we got the spot right smack in front of the United States Supreme Court, and I will never forget addressing that crowd that day, and how important it was. So we argue the case. We feel pretty good about it, but over the summer, we start hearing rumors that Justice O'Connor has switched sides and that we're going to lose. So it goes to the final day of the term, 4 cases remaining. CNN asks me and one of my nemeses to be prepared to speak immediately after the decision comes down. And down in the basement of the Supreme Court, they hand out copies of the opinion to reporters who then race out to do their stories. My partner Chip Meller and I were down in the basement waiting to hear what was going to happen. And so as I said, there were 4 cases, final term of the court. First case isn't ours. Second case isn't ours. Third case isn't ours. And then nothing. We're like, what's going on? And I look over at Chip and I said, someone is reading a dissent from the bench, which they sometimes do. And he said, I know. And I said, you know who most reads dissents from the bench? I know, Scalia. And we're like, if Scalia's reading a dissent, we're done. So that morning I had practiced 2 different messages in the shower. And when I practiced the message for losing, I had tears coming down my face. I am like, we have to win this case. And finally, the decision comes out. The reporters thrust a copy in my hand. All I can do is to see who wrote it. I see Rehnquist. And I'm like, we won. And we get out, and I am able to use the winning line that I practiced in the shower that morning. And that winning line was, today was the Super Bowl for school choice, and the kids won. Pierce versus Society of Sisters set the foundation for that decision. Brown versus Board of Education many years later. The battle for parental autonomy is far from over. All you have to do to know that is to read the dissenting opinions in Zellman, and those views still exist on the U.S. Supreme Court. Justice Stevens said, is a law that authorizes the use of public funds to pay for the indoctrination of thousands of grammar school children, in particular religious faiths, a law respecting an establishment of religion? And of course, he answers the question that he framed that way, an emphatic yes. He poo-poos the idea of voluntary choices, which was the centerpiece of the court's decision. Money flows to religious schools only as the result of independent choices by parents among a wide range of educational options. And he says the voluntary aspect of it is not real. Justice Breyer predicts religiously based social conflict. We now have, over 20 years from that decision, I have not seen a moment of religiously based social conflict as a result of school choice programs. But it was, as often is the case, Justice Thomas who I think gets the best word, and he gets the best word from quoting one of his heroes. And I will end my remarks with this quote. Education means emancipation. It means light and liberty. It means the uplifting of the soul of man into the glorious light of truth, the light by which men can only be made free. Those words from Frederick Douglass. And you, all of you at CAPE, are foot soldiers in the war to bring enlightenment to our country, to the precious young minds that attend your schools. And I'll finish with the only Latin that this lawyer cares about, carpe diem. Thank you so much. Thank you. Thank you. Hopefully you can tell that I really am happy to be here. So we have a few minutes for questions before I get the hook and you hear from, you stop hearing from the warm-up act. Any? Yeah.
So one of the things in the cases that have come since Zelman, this question arises about this direct, indirect funding distinction. So from my cards table, I don't think it exists anymore, if it ever did. Do you think it is still a thing?
So that's an awfully good question, and I hope to learn the answer from you in a few minutes. But it certainly has dissipated as a factor in U.S. Supreme Court cases, and the court, as I know you will talk about, has moved toward emphasizing neutrality and non-discrimination. In 20 years, we moved from a 5-4 decision allowing private schools and religious schools to be an option, 20 years later, to saying by an even bigger vote that they cannot be excluded. That is a massive move in a really, really short period of time when you consider how much time passed between Pierce and Zelman, and then only 20 years since then. So I think that the answer is no, it has dissipated, but it was certainly the factor in which we were able to hitch the constitutionality of the Cleveland program. One more? Yeah.
Is the Pierce decision something that's still cited in a lot of court decisions? Has it been pretty consistently over the last?
Yes, it is very robust, and not even just in education decisions, but my court has had, since I've been on the court, a lot of termination of parental rights cases, and it pains me to say that I am almost always in the dissent in those cases. And I cite Pierce all the time because the principle that Pierce establishes is not just education, but rather in this free country, parents are the primary decision makers for their children. And one of the nifty things about Pierce, we're almost lucky that the court had not yet incorporated freedom of religion. If this case had been decided on freedom of religion grounds, it would have much narrower impact. But it was decided on parental liberty grounds, and that applies to, guess what? All parents. And so, and we'll see, as Nicole talks about the Mahmoud case, that idea really is in the centerpiece. It works in the court today. Those two concepts are very, very hand in hand. And I think, we're getting to where we should have been a long time ago. And with that, again, thank you, and go get 'em.